Part 15, Realm and Commonwealth by Spiers. Copyright 2018. 31. A victorious army appropriates all public money, seizes all public movable properties until further direction by its government, and sequestered, for all its benefit, or of its government, all the revenue of real property belonging to the hostile government or nation. The title of such real property remains in abeyance during military occupation and until the conquest is made complete. 32. A victorious army, by the martial power inherent in the same, may suspend, change, or abolish, as far as the martial power extends, the relations which arise from the services due, according to the existing laws of the invaded country, from one citizen, subject, or native of the same to another. The commander of the army must leave it to the ultimate treaty of peace to settle the permanency of this change. 33. It is no longer considered lawful. On the contrary, it is held to be a serious breach of the law of war to force the subjects of the enemy into the service of the victorious government, except the latter should proclaim, after a fair and complete conquest of the hostile country or district, that it is resolved to keep the country, district, or place permanently as its own, and make it a portion of its own country. 34. As a general rule, the property belonging to the churches, to hospitals, or other establishments of an exclusively charitable character, to establishments of education or foundations for the promotion of knowledge, whether public schools, universities, academies of learning, or observatories, museums of the fine arts, or of a scientific character, such property is not to be considered public property in the sense of paragraph 31, but it may be taxed or used when the public service may require it. 35. Classical works of art, libraries, scientific collections, or precious instruments such as astronomical telescopes, as well as hospitals, must be secured against all avoidable injury, even when they are contained in fortified places whilst besieged or bombarded. 36. If such works of art, libraries, collections, or instruments belonging to a hostile nation or government can be removed without injury, the ruler of the conquering state or nation may order them to be seized and removed for the benefit of the said nation. The ultimate ownership is to be settled by the ensuing treaty of peace. In no case they to be sold or given away, if captured, by the armies of the United States, nor shall they ever be privately appropriated, or wantonly destroyed or injured. 37. The United States acknowledge and protect in hostile countries occupied by them religion and morality, strictly private property, the persons of the inhabitants, especially those of women, and the sacredness of domestic relations. Offences to the contrary shall be rigorously punished. This rule does not interfere with the right of the victorious invader to tax the people or their property, to levy forced loans, to billet soldiers, or to appropriate property, especially houses, lands, boats, or ships, and the churches for temporary and military use. 38. Private property. Unless fortified by crimes or by offences of the owner, can be seized only by way of military necessity for the support or other benefit of the Army or of the United States. If the owner has not fled, the commanding officer will cause receipts to be given, which may serve the spoliated owner to obtain indemnity. 39. The salaries of civil officers of the hostile government who remain in the invaded territory and continue to work of their office and can continue it according to the circumstances arising out of the war, such as judges, administrative or political officers, officers of city or communal government, are paid from the public revenue of the invaded territory until the military government has reason wholly or partially to discontinue it. Salaries or income connected with purely honorary titles are always stopped. 40. There exists no law or body of authoritative rules of actions between hostile armies except that the branch of the law of nature and nations, which is called the law and usages of war on land. 41. All municipal law of the ground on which the armies stand or of the countries to which they belong is silent and of no effect between armies in the field. 42. Slavery, complicating and confounding the ideas of property, that is, of a thing, and of personality, that is, of humanity, exists according to municipal or local law only. The law of nature and nations has never acknowledged it. The digest of the Roman law enacts the early dictum of the pagan jurist that, so far as the law of nature is concerned, all men are equal. Fugitives escaping from a country in which they were slaves, villains, or serfs into another country have, for centuries past, been held free and acknowledged free by judicial decisions of European countries, even though the municipal laws of the countries in which the slave has taken refuge acknowledge slavery within its own dominions. 43. Therefore, in a war between the United States and a belligerent which admits of slavery, if a person held in bondage by that belligerent be captured by or come as a fugitive under the protection of the military forces of the United States, such person is immediately entitled to the rights and privileges of a freeman. To return such person into slavery would amount to enslaving a free person, and neither the United States nor any officer under their authority can enslave any human being. Moreover, a person so made free by the law of war is under the shield of the law of nations, and the former owner or state can have, by the law of poslimony, no belligerent lien or claim of service. 44. All wanton violence committed against persons in the invading country, all destruction of property not commanded by the authorized officer, all robbery, all pillage or sacking, even after taking a place by main force, all rape, wounding, maiming, or killing of such inhabitants are prohibited under the penalty of death, or such other severe punishment as may seem adequate for the gravity of the offence. A soldier, officer, or private in the act of committing such violence or disobeying a superior ordering him to abstain from it may be lawfully killed on the spot by such superior. 45. All captures and booty belong, according to the modern law of war, primarily to the government of the captor. Prize money, whether on sea or land, can now only be claimed under local law. 46. Neither officers nor soldiers are allowed to make use of their position or power in the hostile country for private gain, not even for commercial transactions otherwise legitimate. Offences to the contrary committed by commissioned officers will be punished with cashiering or such other punishment as the nature of the offence may require. If by soldiers, they shall be punished according to the nature of the offence. 47. Crimes punishable by a penal code, such as arson, murder, maiming, assaults, highway robbery, theft, burglary, fraud, forgery, and rape, if committed by an American soldier in a hostile country against its inhabitants, are not only punishable as at home, but in all cases in which death is not inflicted, the severer punishment shall be preferred. Section 3. Deserters, prisoners of war, hostages, booty on the battlefield. 48. Deserters from the American army having entered the service of the enemy suffer death if they fall again into the hands of the United States, whether by capture or being delivered up to the American army. And if a deserter from the enemy having taken service in the Army of the United States is captured by the enemy and punished by them with death or otherwise, it is not a breach against the law and usage of war, requiring redress or retaliation. 49. A prisoner of war is a public enemy armed or attached to the hostile army for active aid, who has fallen into the hands of the captor, either fighting or wounded, on the field or in the hospital, by individual surrender or by capitulation. All soldiers of whatever species of arms, all men who belong to the rising en masse of the hostile country, all those who are attached to the army for its efficiency and promote directly the object of the war, except such as are hereinafter provided for. All disabled men or officers on the field or elsewhere, if captured, all enemies who have thrown away their arms and ask for quarter are prisoners of war, and as such exposed to the inconveniences as well as entitled to the privileges of a prisoner of war. 50. Moreover, citizens who accompany an army for whatever purpose, such as suitors, editors, or reporters of journals or contractors, if captured, may be made prisoners of war and be detained as such. The monarch and members of the hostile reigning family, male or female, the chief and chief officers of the hostile government, its diplomatic agents, and all persons who are of particular or singular use and benefit to the hostile army or its government are, if captured on belligerent grounds, and if unprovided with a safe conduct granted by the captor's government, prisoners of war. 51. If the people of that portion of invaded country which is not yet occupied by the enemy, or of the whole country, at the approach of a hostile army, rise under a duly authorized levy en masse to resist the invader, they are now treated as public enemies, and if captured, are prisoners of war. 52. No belligerent has the right to declare that he will treat every captured man in arms as a levy en masse, as a brigand or bandit. If, however, the people of the country or any portion of the same already occupied by an army rise against it, they are violators of the laws of war and are not entitled to their protection. 53. The enemy's chaplains, officers of the medical staff, apothecaries, hospital nurses, and servants, if they fall into the hands of the American army, are not prisoners of war unless the commander has reason to retain them. In this latter case, or if at their own desire they are allowed to remain with their captured companions, they are treated as prisoners of war and may be exchanged if the commander sees fit. 54. A hostage is a person who accepted as a pledge for the fulfillment of an agreement concluded between belligerents during the war or in consequence of a war. Hostages are rare in the present age. 55. If a hostage is accepted, he is treated like a prisoner of war according to rank and condition, as circumstances may admit. 56. A prisoner of war is subject to no punishment for being a public enemy, nor is any revenge wreaked upon him by the intentional infliction of any suffering or disgrace, by cruel imprisonment, want of food, by mutilation, death, or any other barbarity. 57. As soon as a man is armed by a sovereign government and takes the soldier's oath of fidelity, he is a belligerent. His killing, wounding, or other warlike acts are no individual crimes or offences. No belligerent has a right to declare that enemies of a certain class, colour, or condition, when properly organised as soldiers, will not be treated by him as public enemies. 58. The law of nation knows of no distinction of colour, and if an enemy of the United States should enslave and sell any captured person of their army, it would be a case for the severest retaliation, if not redressed upon complaint. The United States cannot retaliate by enslavement. Therefore, death must be the retaliation for this crime against the laws of nations. 59. A prisoner of war remains answerable for his crimes committed against the captor's army or people, committed before he was captured, and for which he has not been punished by his own authorities. All prisoners of war are liable to the infliction of retaliatory measures. 60. It is against the usage of modern war to resolve in hatred and revenge, to give no quarter. No body of troops has the right to declare that it will not give and therefore will not expect quarter, but a commander is permitted to direct his troops to give no quarter in great straits, when his own salvation makes it impossible to cumber himself with prisoners. 61. Troops that give no quarter have no right to kill enemies already disabled on the ground or prisoners captured by other troops. 62. All troops of the enemy known or discovered to give no quarter in general or to any portion of the army receives none. 63. Troops who fight in the uniform of their enemies without any plain, striking, or uniform mark of distinction of their own can expect no quarter. 64. If American troops capture a train containing uniforms of the enemy and the commander considers it advisable to distribute them for use among his men, some striking mark or sign must be adopted to distinguish the American soldier from the enemy. 65. The use of the enemy's national standard flag or other emblem of nationality for the purpose of deceiving the enemy in battle is an act of perfidy, by which they lose all claim of protection of the laws of war. 66. Quarter having been given to an enemy by American troops under a misapprehension of his true character, he may, nevertheless, be ordered to suffer death if, within 3 days after the battle, it be discovered that he belongs to a corps which gives no quarter. 67. The laws of nations allow every sovereign government to make war upon another sovereign state, and therefore admits of no rules or laws different from those of regular warfare regarding the treatment of prisoners of war, although they may belong to the army of a government which the captor may consider as a wanton and unjust assailant. 68. Modern wars are not internecine wars, in which the killing of the enemy is the object. The destruction of the enemy in modern war, and indeed modern war itself, are means to obtain that object of the belligerent which lies beyond the war. Unnecessary or revengeful destruction of life is not lawful. 69. Outposts, sentinels, or pickets are not to be fired upon except to drive them in, or when a positive order, special or general, has been issued to that effect. 70. The use of poison in any manner, be it to poison wells or food or arms, is wholly excluded from modern warfare. He that uses it puts himself out of the pale of the law of usages of war. 71. Whoever intentionally inflicts additional wounds on any enemy already wholly disabled, or kills such an enemy, or who orders or encourages soldiers to do so, shall suffer death, if duly convicted, whether he belongs to the army of the United States or to an enemy captured after having committed his misdeed. 72. Money and other valuables on the person of a prisoner, such as watches or jewelry, as well as extra clothing, are regarded by the American Army as the private property of the prisoner, and the appropriation of such valuables or money is considered dishonorable and is prohibited. Nevertheless, if large sums are found upon the persons of prisoners or in their possession, they shall be taken from them, and the surplus, after providing for their own support, appropriated for the use of the army under the direction of the commander. unless otherwise ordered by the government. Nor can prisoners claim as private property large sums found and captured in their train, although they have been placed in the private luggage of the prisoners. 73. All officers, when captured, must surrender their sidearms to the captor. They may be restored to the prisoner in marked cases by the commander to signalise admiration of his distinguished bravery or approbation of his humane treatment of prisoners before his capture. The captured officer to whom they may be restored cannot wear them during captivity. 74. A prisoner of war, being a public enemy, is the prisoner of the government and not of the captor. No ransom can be paid by a prisoner of war to his individual captor or to any officer in command. The government alone releases captives according to rules prescribed by itself. 75. Prisoners of war are subject to confinement or imprisonment such as may be deemed necessary on account of safety, but they are to be subjected to no other intentional suffering or indignity. The confinement and mode of treating a prisoner may be varied during his captivity according to the demands of safety. 76. The prisoners of war shall be fed upon plain and wholesome food whenever practicable and treated with humanity. They may be required to work for the benefit of the captor's government according to their rank and position. 77. A prisoner of war who escapes may be shot or otherwise killed in his flight, but neither death nor any other punishment shall be inflicted upon him simply for his attempt to escape, which the law of war does not consider a crime. Stricter means of security shall be used after an unsuccessful attempt at escape. If, however, a conspiracy is discovered, the purpose of which is a united or general escape, the conspirators may be rigorously punished, even with death, and capital punishment may also be inflicted upon prisoners of war discovered to have plotted rebellion against the authorities of the captors, whether in union with fellow prisoners or other persons. 78. If prisoners of war, having given no pledge nor made any promise on their honour, forcibly or otherwise escape, and are captured again in battle, having rejoined their own army, they shall not be punished for their escape, but shall be treated as simple prisoners of war, although they will be subjected to stricter confinement. 79. Every captured, wounded enemy shall be medically treated according to the ability of the medical staff. 80. Honourable men, when captured, will abstain from giving to the enemy information concerning their own army, and the modern law of war permits no longer the use of any violence against prisoners in order to extort the desired information or to punish them for having given false information. Section 4. Partisans, armed enemies not belonging to the hostile army, scouts, armed prowlers, war rebels. 81. Partisans are soldiers armed and wearing the uniform of their army, but belong to a corps which acts detached from the main body for the purpose of making inroads into the territory occupied by the enemy. If captured, they are entitled to all the privileges of a prisoner of war. 82. Men or squads of men who commit hostilities, whether by fighting or inroads for destruction or plunder, by raids of any kind, without commission, without being part and portion of the organized hostile army, and without sharing continuously in the war, but who do so with intermitting returns to their homes and avocations, or with the occasional assumption of the semblance of peaceful pursuits, divesting themselves of the character or appearance of soldiers, such men or squads of men are not public enemies, and therefore, if captured, are not entitled to the privileges of prisoners of war, but shall be treated summarily as highway robbers or pirates. 83. Scouts or single soldiers, if disguised in the dress of the country, or in the uniform of the army hostile to their own, employed in obtaining information, if found within or lurking about the lines of the captor, are treated as spies and suffer death. 84. Armed prowlers, by whatever names they may be called, or persons of the enemy's territory who steal within the lines of the hostile army for the purpose of robbing, killing, or of destroying bridges, roads, or canals, or of robbing or destroying the mail, or of cutting the telegraph wires, are not entitled to the privileges of a prisoner of war. 85. War rebels are persons within an occupied territory who rise in arms against the occupying or conquering army, or against the authorities established by the same. If captured, they may suffer death, whether they rise singly or in small or large bands, and whether called upon to do so by their own, but expelled government or not. They are not prisoners of war, nor are they, if discovered and secured before their conspiracy has matured to an actual rising or to armed violence. Section 5. Safe conduct, spies, war traitors, captured messengers, abuse of the flag of truce. 86. All intercourse between the territories occupied by belligerent armies, whether by traffic, by letter, by travel, or in any other way, ceases. This is the general rule, to be observed without special proclamation. Exemptions to this rule, whether by safe conduct or permission to trade on a small or large scale, or by exchanging mails, or by travel from one territory into the other, can take place only according to agreement approved by the government or the highest military authority. Contraventions of this rule are highly punishable. 87. Ambassadors and all other diplomatic agents of neutral powers accredited to the enemy may receive safe conducts through the territories occupied by the belligerents, unless there are military reasons to the contrary, and unless they may reach the place of their destination conveniently by another route. It implies no international affront if the safe conduct is declined. Such passes are usually given by the supreme authority of the state and not by subordinate officers. 88. A spy is a person who secretly, in disguise, or under false pretense, seeks information with the intention of communicating it to the enemy. The spy is punishable with death by hanging by the neck, whether or not he succeed in obtaining the information or in conveying it to the enemy. 89. If a citizen of the United States obtains information in a legitimate manner and betrays it to the enemy, be he a military or civil officer or a private citizen, he shall suffer death. 90. A traitor under the law of war or a war traitor is a person in a place or district under martial law who, unauthorized by the military commander, gives information of any kind to the enemy or holds intercourse with them. 91. The war traitor is always severely punished. If his offence consists in betraying the enemy anything concerning the conditions, safety, operations, or plans of the troops holding or occupying the place or district, his punishment is death. 92. If the citizen or subject of the country or place invaded or conquered gives information to his own government from which he is separated by the hostile army, or to the army of his government, he is a war traitor, and death is the penalty of his offence. 93. All armies in the field stand in need of guides, and impress them if they cannot obtain them otherwise. 94. No person having been forced by the enemy to serve as guide is punishable for having done so. 95. If a citizen of a hostile and invaded district voluntarily serves as a guide to the enemy or offers to do so, he is deemed a war traitor and shall suffer death. 96. A citizen serving voluntarily as a guide against his own country commits treason and will be dealt with according to the law of his country. 97. Guides, when it is clearly proved that they have misled intentionally, may be put to death. 98. All unauthorized or secret communication with the enemy is considered treasonable by the law of war. Foreign residents in an invaded or occupied territory of foreign visitors in the same can claim no immunity from this law. They may communicate with foreign parts or with the inhabitants of the hostile country, so far as the military authority permits, but no further. Instant expulsion from the occupied territory would be the very least punishment for the infraction of this rule. 99. A messenger carrying written dispatches or verbal messages from one portion of the army or from a besieged place to another portion of the same army or its government, if armed and in uniform of his army, and if captured while doing so in the territory occupied by the enemy, is treated by his captor as a prisoner of war. If not in uniform nor a soldier, the circumstances connected with his capture must determine the disposition that shall be made of him. 100. A messenger or agent who attempts to steal through the territory occupied by the enemy to further in any manner of interests of the enemy is captured, is not entitled to the privileges of a prisoner of war, and may be dealt with according to the circumstances of the case. 101. While deception in war is admitted as just and necessary means of hostility and is consistent with honourable warfare, the common law of war allows even capital punishment for clandestine or treasonous or treacherous attempts to injure an enemy, because they are so dangerous and it is so difficult to guard against them. 102. The law of war, like the criminal law regarding other offences, makes no difference on account of the difference of sexes concerning the spy, the war trader, or the war rebel. 103. Spies, war traders, and war rebels are not exchanged according to the common law of war. The exchange of such person would require a special cartel authorized by the government or at a great distance from it by the chief commander of the army in the field. 104. A successful spy or war trader safely returned to his own army and afterwards captured as an enemy is not subject to punishment for his acts as a spy or war trader, but he may be held in closer custody as a person individually dangerous. Section 6. Exchange of prisoners, flags of truce, flags of protection. 105. Exchanges of prisoners take place number for number, rank for rank, wounded for wounded, with added condition for added condition, such, for instance, as not to serve for a certain period. 106. In exchanging prisoners of war, such numbers of persons of inferior rank may be substituted as the equivalent for one of a superior rank, as may be agreed upon by the cartel, which requires the sanctions of the government or of the commander of the army in the field. 107. A prisoner of war is an honour bound truly to state to the captor his ranks, and he is not to assume a lower rank than belongs to him, in order to cause a more advantageous exchange, nor a higher rank for the purpose of obtaining better treatment. Offences to the contrary have been justly punished by the commanders of released prisoners, and may be good cause for refusing to release such prisoners. 108. The surplus numbers of prisoners of war remaining after an exchange has taken place is sometimes released, either for the payment of a stipulated sum of money or, in urgent cases, in provision, clothing, or other necessities. Such arrangements, however, require the sanction of the highest authority. 109. The exchange of prisoners of war is an act of convenience to both belligerents. If no general cartel has been concluded, it cannot be determined by either of them, no belligerent is obliged to exchange prisoners of war. A cartel is voidable as soon as either party has violated it. 110. No exchange of prisoners shall be made except after complete capture and after the accurate account of them and a list of the captured officers has been taken. 111. The bearer of a flag of truce cannot insist upon being admitted. He must always be admitted with great caution, Unnecessary frequency is carefully to be avoided. 112. If the bearer of a flag of truce offers himself during an engagement, he can be admitted as a very rare exception only. It is no breach of good faith to retain such a flag of truce, if admitted during the engagement. Firing is not required to cease on the appearance of a flag of truce in battle. 113. If the bearer of a flag of truce presenting himself during an engagement is killed or wounded, it furnishes no ground of complaint whatsoever. 114. If it be discovered and fairly proved that the flag of truce has been abused for surreptitiously obtaining military knowledge, the bearer of the flag thus abusing his sacred character is deemed a spy. So sacred is the character of a flag of truce, and so necessary is its sacredness, that while its abuse is an especially heinous offence, great caution is requisite, on the other hand, in convicting the bearer of a flag of truce as a spy. It is customary to designate by certain flags, usually yellow, the hospitals in places which are shelled, so that the besieging enemy may avoid firing on them. The same can be done in battles when kitchens are situated within the fields of the engagement. 116. Honourable belligerents often request that the hospitals within the territory of the enemy may be designated so that they may be spared. An honourable belligerent allows himself to be guided by flags or symbols of protection as much as contingencies and the necessity of the fight will permit. 117. It is justly considered an act of bad faith or infamy or fiendishness to deceive the enemy by flags of protection. Such act of bad faith may be good cause for refusing to respect such flags. 118. The besieging belligerent has sometimes requested the besieged to designate the buildings contained collection of works of arts, scientific museums, astronomical observations, or precious libraries, so that their destruction may be avoided as much as possible.